Okay, it's 9 o'clock. Have the pledge, please, first. I pledge
Allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
We're looking for approval of the minutes from last meeting.
Second.
First and second, any discussion?
Yeah, we need to. It said it was unanimous vote for the hanger, and it wasn't. Both Tom and I were down.
We got your email.
Okay, did you fix that?
Yeah, yep.
Right, so,
Okay, so
so then we're all set then.
that's changed, I guess. Yeah.
Okay. All in favor?
Aye.
Opposed? Carries. First up, we have a resolution accepting the Board of Elections early voting grant.
They gave us a, capital project grant for the amount of $78,994.07. And, Jim Leatherip signed off on those, and we would like to be able to, create an account for next year to accept it in to our budget.
Right.
Make the motion. I'll second.
Okay, first and second, any further discussion? All in favor?
Aye.
Okay, carries, thank you. Next, we have a resolution authorizing budget mod for the Board of Elections reproduction expenses.
Yeah, we're moving some money around to cover the cost of the ballots for this year's general election, and we need to do that so we can pay for those.
Came from trucking, or the school budgets, mainly the trucking is what we charge for on that.
Right.
And we had several, elections above and beyond what they normally have in May, so.
Okay, and
We
that's
had extra
coming out
money.
of your own budget line.
Yep.
Second.
First and second, any other discussion? If not, all in favor?
Aye.
Opposed? Carries. Next up, we have a resolution authorizing the budget mod for the county clerk, motor vehicle additional hours.
Yeah, fairly straightforward, just moving some money around. We utilize the monies that we had within our budget for, the overtime is approved last month. That worked out very, very well for us. We spent about $2,500. We made about $14,000. So good use of time, good use of money, good use of resources, and thankfully with all my staff attended it. But in doing that, we ran over all of our additional hours. So we just need to put money that's within our budget into this line, help get through the rest of the year.
Yeah, thank you.
Move it. Second.
Okay, we have first and second, any other discussion on that? If not, all in favor?
Aye.
Carries, thank you.
Thank you.
All right, next up, we have a resolution accepting the local government records management improvement fund grant.
Yeah, I might as well stay standing for this one. This is a state archives grant, which we received notice of award several months ago on it. We just received the first draw from that money. We're in the process right now of working with purchasing, Wyandotte County Purchasing, to do all of the requirements to do the actual system. Steve Goodfellow, our records management consultant, is leading the way on that project. This grant will go towards bringing in a county-wide records management system. We'll have kind of a little work group we're gonna work together to kind of put together to see exactly what we want that to be, driven mostly by the departments that we've already started to work with, but to be as comprehensive, to be able to image as many documents as humanly possible across the county.
Okay, so,
Second.
first and second, any other discussion? All in favor?
Aye.
Opposed? Carries.
Thank you very much.
Next up, we have a resolution memorializing the intent of the legislature regarding the need to retain Interstate 81 and its current route through Syracuse.
I'll move it. I'll second.
First and second. Yes,
Yeah, just maybe somebody can shed some light on the timing and why we're moving this now. I mean, the state DOT's held public sessions for the last, seems like a year on the issue. They've come out with a recommendation moving forward with the community grid. I'm just wondering why the legislature is finding this pertinent to move it through, even though it's had a designation come out from the state already.
Terry?
So, in discussions with our partners in Onondaga County along with Cayuga County, We are supporting them 110%. It's in their backyard. We have a great percentage of constituents that travel to Syracuse and through Syracuse, I should say, on 81 daily for their commute. And this is supporting them so that they can have that straight thoroughfare that they currently have. The community grid, as you probably have seen, is going to be quite a change for the city, along with the people who are traveling to and from work daily. So, outside of supporting our colleagues in various counties, which we would hope they would support us on something of this larger scale, I think it's also supporting our constituents who commute to and from Onondaga County or through it.
Yeah, just a follow, Mr. Chairman. So a couple things. I guess my follow-up question, I mean, the resolution is littered with reasons to support the current structure as is, mainly focusing on, you know, what it does for economic development and how that can impact the county. Was this resolution vetted through, you know, we just implemented an economic advancement plan. Out of that economic advancement plan, a steering committee was born. Was this resolution passed through that steering committee?
I don't believe it was. I believe that the reason being is it's supporting the current situation of 81, and 81 was there when that steering committee put the plan together. So.
And I would just follow up that by saying, I believe last month, we partnered with Center State CEO for the implementation of our current economic advancement plan, a partnership with the county, the IDA, and Center State CEO. Center State CEO is very much in favor of the community grid. So it makes me begin to question, you know, that partnership if we're starting up this. I sat on that economic advancement steering committee. 81 wasn't raised hardly at all. I can't remember a time where it was that length of a discussion about the future of 81. And now we're partnering with Center State CEO to implement our economic advancement plan when this resolution hasn't passed through our steering committee, and the people that we just partnered with for tens of thousands of dollars actually don't support what we're proposing today. So that doesn't seem like it was passed through the proper channels to me. So I'm going to be voting against the resolution, A, because I support the community grid, and like you, Legislator Wilbur, I've talked to colleagues, particularly in the city of Syracuse and some of the towns in Onondaga County that actually don't support this whatsoever. The state's ruled on this. There's been multiple times that we could have been in on this conversation. We're not. We didn't pass it through the proper channels here, it seems like. And the people that we're partnering with don't support the resolution that's moving forward today. So I'm not going to be supporting this.
But quite honestly, the economic advancement plan, it's our economic advancement plan, so we're structuring that how we need to. My understanding as Center State CEO is they're going to do the administrative tasks and help us going forward with that. However, when it comes down to it, we are supporting our colleagues in Onondaga County because they passed this resolution along with Cuba County. I believe Cortland's taking it up, and maybe Jefferson will be taking it up this month as well. When it's all said and done, 81 in its current structure, which we're supporting in this resolution, was in place when we did this economic advancement plan. I don't think there was anybody who sat around the table that wanted to discuss 81 because, well, we didn't know where it was directed. We're at the point now where, yeah, they have come out with a community grid, and we're saying, no, that isn't going to be beneficial for our constituents or our county. So I think this is who of our county to stand up and take a stance on the future of 81. Not just for our county as a whole, but to support our neighbors as well. It is your right to support what you want or not support what you want, and that's what government's so good about. So at the end of the day, I'm going to support keeping 81 in its current stance because it's going to be very confusing if they go to that community grid.
Yeah, go ahead.
Well, I just want to clarify something. I think, and correct me if I'm wrong, Tom, but I do think Tom's point is not that 81 didn't exist, but the question of its future was something that was in question while the steering committee was in play. So I think that was his point.
Well, the resolution states, this has been a decision that, people have said it's going to affect the region for the next 100 years. We've been talking about this for years on a regional basis. It just seems like we're working against ourselves a little bit here when we partner with an agency that completely doesn't support the direction that we're deciding to head. So I understand the outside counties are getting together on this. Frankly, there's a ton of politics being played with it, let's just be honest. They didn't like the decision because the decision didn't go a certain way, in my opinion alone. But I believe that's the politics of it. So, we can agree to disagree. It just seems like this should have been passed through a couple more channels here locally. But, I've said my piece, so thank you.
could have brought it through there and maybe probably would have voted no anyway, so it doesn't matter at the end of the day.
It's your opinion on 81, it's our opinion on 81, we're gonna come together and make a decision, hopefully supporting our constituents. At the end of the day, I firmly believe that the community grid is going to slow down all the traffic, bring it to a standstill, and it's gonna add countless minutes on to commutes that are daily for our constituents.
And just to clarify that too, we don't have a homogeneous pool of constituencies, so to say we're supporting our constituents, they may be your constituents, but we all have different constituents that we are supporting, so just to clarify that.
County constituents.
Got anything? Anybody else? Do we have a motion? Okay. Any other discussion? Not, all in favor?
Aye.
Opposed? Two opposed. Okay, next up, we have the county attorney and raise the age presentation.
All right, I'll try and keep this brief because I know you guys have been inundated with different raise the age presentations over time. I don't think this is this isn't first news to anybody, right? Everybody's had some exposure to this raise the age stuff. Yes?
Yes.
Feel free to chime in. All right, first and foremost, we're almost exactly 1 year from the date that the raise the age legislation took effect. Tomorrow marks the 1 year point. As I believe the legislature is well aware, the numbers that we anticipated seeing are far below or far higher than what we're actually seeing. We're not seeing the numbers we anticipated, okay? I believe that the probation department presented numbers to both the legislature and all the different agencies with the county, indicating that we believed we would see roughly 200 juveniles as part of the raise the age program last year. I can't tell you what the actual numbers are that we saw. Part of the reason for that is because when these juveniles come through the probation department as part of intake and diversion, which is the first step of the process for the adolescent offenders, I'm not permitted by law to see that until the intake and diversion portion fails. Out of the numbers that have reached my office, we've had a total of three adolescent offenders that have been charged countywide in 1 calendar year. Now, I would suggest that's not healthy. I don't believe by any stretch of the imagination that our 16-year-old population, we only had 3 individuals that committed crimes countywide for the calendar year of 2019. I just don't believe it. I think the biggest issue that we're seeing is law enforcement doesn't know how to handle these cases because they're so complicated. And when you add into the mix that they're not quite sure what to do, this legislation creates so many hurdles that law enforcement has to jump through in order to process a 16-year-old and beginning tomorrow a 17-year-old. So it becomes there's so many man hours behind each individual adolescent offender arrest that I believe that law enforcement, is erring on the side of doing nothing. Now, in order to combat that, the county attorney's office, Courtney Haviland and myself, have been traveling to each one of the law enforcement agencies to provide training. We've met with the Oswego City Police Department on 2 separate occasions, the Fulton City Police Department on 3 separate occasions, State Police, 2 separate occasions, and then I traveled out to SUNY Oswego to meet with campus police on 2 separate occasions as well. Now, we acknowledge that we're still kind of missing the small village and town police departments, but that's something we're still hoping to schedule and coordinate with them to provide the training. And so everybody knows I make myself available 24 hours a day for the training as well. So frequently we'll find with the shifts that law enforcement works, sometimes 7 o'clock at night is the best time to provide the training. I'll make myself available and do it after hours, and Courtney will too, to make sure that we're all on the same page. But here's the underlying issue now. If you've been through these raise the age PowerPoint presentations around the state, I believe the message that may have been sent is that the state is trying to shift the paradigm to focus back on rehabilitation. We're trying to rehabilitate the youth. The perception that I've seen in Oswego County is the state is trying to solve a problem that we don't have in Oswego County, that we've never had in Oswego County. And I jumped into that belief initially as well, that we didn't have this problem and they were forcing the system on us. I have since shifted my viewpoint, and here's why. While we didn't have a problem that New York City had in regards to 16 and 17-year-old crime and what the punishments were, we really didn't focus on rehabilitation either when it came to the 16 and 17-year-old age group. We had a very high number of 16 and 17-year-olds that received an ACD, or an adjournment and contemplation of dismissal. They kept their nose clean for 6 months, and that was the end of it. That's a great outcome for 16 and 17-year-olds, but what we found is there's no correlation to receiving an ACD and then not re-engaging in future crime. So there are benefits to this legislation if we really do focus on the rehabilitative aspects. We understand that family court has more programs than the criminal court system has available, simply because of the funding streams. And I don't need to lecture the legislature on funding streams. I think you guys know a lot more about it than I do. But because of the way they're set up, family court has a lot more different ways to fund programs and try and achieve this rehabilitative purpose. So where are we at today? Where we're at today is, like I said before, the numbers are very, very low, but I caution everybody on focusing on those numbers, because it could be overnight that the numbers resurface to what we expect them to be. At some point in time, law enforcement is going to change their approach to how they're dealing with these 16 and now 17-year-olds starting tomorrow, because the public outcry is going to be too high. I mean, at some point in time, our constituents are going to become upset that these 16 and 17-year-olds are not being held accountable. And at some point, law enforcement will begin to arrest more adolescent offenders, issue more appearance tickets. And because it is so much more time consuming with the process, the man hours are going to climb considerably. From start to finish, the way that the district attorney's office prosecuted a 16 or a 17-year-old prior to raise the age might have taken a fraction of the amount of time to prosecute a matter that it would now take under the current raise the age system. That was in every way intended when they put this legislation together. They intended for it to be much more complex because they want us to focus on every little detail to make sure that we get the rehabilitative aspects right. Now, with that message, does anybody have any very pointed questions? I don't need to go through a whole PowerPoint presentation because I truly believe you guys have been inundated with this stuff. I do consider myself to be like the resident expert here in Oswego County. I'm in family court all day, every day. This is kind of my baby, so if you have any questions, I think I might be your guy. And I'm no nonsense. I'll tell you what I really think about it too.
Well, obviously, you just appointed yourself as the expert.
Oh, no,
And I'm
Obviously,
doing
he's well versed in this. He's done research beyond the statute, looked at advisory committee on family court recommendations of change to raise the age. We met with other county attorneys in the western region, discussed raise the age, and he's gone to prosecutors conferences, discussed that. So he's very well versed on that, and his duties are solely in family court. So he has the child support and JDs as well, and PINs. So
I do know that like probation hasn't seen any of the numbers either like they have. And I know when probation talks to other counties, they're hearing the same thing. Are you hearing a different story from the family court attorney side of this, or?
With the exception of Onondaga County, when we look at the central New York region, Onondaga County is an outlier. Their numbers have been exactly what they anticipated they were going to be. They're very high. If you hear the legal community talk about that, they believe that it was DA Fitzpatrick's personal agenda to make sure that those numbers stayed consistent so that they gave it a fair shot at the rehabilitative program that the state intended. I don't believe that the other counties, and it may be a resource issue, other counties are experiencing the same problems that we are experiencing now. That, for instance, when we deal with a 16 or a 17-year-old now, law enforcement may have to transport that juvenile all the way to Albany upon arrest, given the nature of the arrest. If it's a violent crime and that kid needs to be remanded to detention, that's a long trip and our sheriff's office has done it on multiple occasions over the last couple of months because the beds are simply not available, become so time consuming. So we have agencies, and I'm speculating here, we have agencies that look at a 12-hour round trip processing of an adolescent offender, and maybe they decide to go a different route that's less restrictive and not issue the appearance ticket, or issue an appearance ticket instead of spinning up the whole system and remanding them to a detention facility. Now, the other problem that we have here too is I think law enforcement agencies struggle when it comes time to reach a magistrate after hours. So they make a phone call or two and give up on the process and issue an appearance ticket. And if that doesn't follow the legal mechanism, it results in an outright dismissal down the road. So we have to be very careful that we get everybody on board to play the game the right way. And like I said, the county attorney's office has been out to train a number of the different agencies. That's not going to end anytime soon. I continue to encourage them to contact us 24 hours a day. Courtney Haviland and I do take phone calls 24 hours a day from law enforcement to answer any questions they might have. And I truly think that you're going to see the numbers pick up starting this year. With the 17-year-olds, I think that will be the straw that breaks the camel's back, and you'll see the numbers come up to where they need to be to protect the community.
You think the numbers are gonna be in the 200 range then? I mean, that's what you're anticipating for
This calendar year, it's possible. I don't want to jump right out on that limb and say that all of a sudden now we're going to go from 0 to 100. I think you're going to see a phase in. I think that certain agencies will get on board quicker than others. Probably the city agencies and the sheriff's office will be the first ones to really jump into this program. And then the towns and the villages will slowly follow behind. But I've got no reason to believe that within the next calendar year, we aren't back close to those numbers. I mean, we've gone through our struggling phase now, and I think we're going to be coming out the other side. You know, and if I can add just one more thing to that, nobody can predict when the numbers are gonna really just jump right up. I mean, my experience working with law enforcement officials, when they decide they're going to start doing something differently, they go all in to start doing it differently. There is no methodical and slow approach to changing things.
Right.
I suspect that once they decide to start doing it, we will be inundated like we anticipated. Did you have a question, Doug?
Yeah, I was wondering where we are with the common arraignment.
You probably don't know anything.
I can't speak to that specifically. I know Sarah Davis was a big part of the central arraignment system. I have not participated in those meetings. The only thing that I can say is that as it impacts the Raise the Age program, we intend to fully use the centralized arraignment system to arraign our adolescent offenders, but I have not been given an updated timeline.
So at this point in time, we're waiting on legislation to be signed by the governor. It's already passed both houses. It's actually an Office of Court Administration program bill. So there's multiple counties that are waiting on this right now. Once that's signed, then we have to do our construction. The Sheriff and I have talked about the construction. We're looking at about $32,000 thereabouts. Everything's pretty much laid out, ready to go, but we made the decision that, well, hold off on that. What if this bill doesn't get signed? Because we need this legislation in order for the sheriff to hold these pre-arraigned individuals in his custody under corrections law. He can't do that currently. So that needs to be changed before we can move forward. Outside of that, the plan's already been submitted. Judge Murphy's working with us on that. It looks like all signs are kind of a go for this. It's just trying to get that legislation signed and then get the construction done and move forward.
It's important to remember, however, that the chapter amendment to 500C of the corrections law to allow our public safety center correctional facility to be used as a detention facility does not apply to adolescent offenders that cannot be held within the jail.
Right.
So the centralized arraignment part will be helpful to have a youth part, do the arraignments as may be necessary, but those 16, 17-year-olds cannot be held in the correctional facility.
to my understanding, and it's even as far along as they have a rotational list set up for the magistrates that'll be doing the arraignments as well. So pretty much waiting on a signature right now.
Thanks.
Terry covered just about everything. I met with Sarah Davis Friday, and the plan that Legislator Wilbur mentioned is with Judge Murphy right now, and Sarah is making contact with them to try to push it through for approval. Yes, the bill's hasn't been asked for by the governor yet, and meeting with the sheriff today to try to fine tune what the budgetary arrangement is going to be to provide staff to the capital.
Thanks.
Del, I apologize, I had to step out. Did you speak generally about PINs and JD as well, or is it?
I didn't discuss the PINs because PINs wasn't actually included in the raise the age legislation. However, there were a number of different talks about the future of the PINs program. And for those of you that don't know PINs, it's person in need of supervision. These are our cases with the juveniles up to the age of 18 for the purpose of that term that fail to attend school regularly, fail to follow rules within the home, potentially runaway kids, that sort of thing. The future of these types of cases is in a great deal of jeopardy right now. The state has not taken away our ability to file against these persons in need of supervision, but what it has done is effective January 1st, it strips all reimbursement for any placements that could arise through these placements. Now, what I've experienced is, in the number of PINs filings that we have in this county, we do have quite a few as it relates to juvenile delinquency proceedings, primarily because we truly embrace the least restrictive means approach for our juveniles. And if we have a kid that's engaged in some negative behaviors in the school setting, rather than immediately charge that child as a juvenile delinquent, our school officials and the Department of Social Services likes to go through the PINs process and bring them in on those types of offenses first. What that does for us is we get into the courtroom, if we don't have the ability to achieve that reimbursement now, it's a grave concern about how we achieve rehabilitative services without the reimbursement aspect from the state. Now, I know commissioners of social services across the state are continuing to lobby to try and change these laws. I don't know how successful they will be. What I can tell you is that as recent as last November, when I attended a county attorney's conference in Albany, we did have state representatives that were present, that were part of this legislation, that assured us up and down that this was not going to happen and that it was merely a placeholder and that the state had absolutely no intention of pulling this funding, and then they did. So what I would caution going forward is nobody really knows what the state's intention is about PINs at this point because they haven't been completely honest with anybody. They're telling everybody a different story. So when it relates to PINs, what we need to be prepared for is that we will encounter some of those worst case scenarios where we have a kid that just continually runs away, will not stay home. As a county, we're going to have to come up with a solution to that problem. Sometimes it's going to cost the county more money than it would have cost in the past, and we need to put our heads together. The legislature, the Department of Social Services, the county attorney's office, law enforcement. We need to come up with a way of identifying which cases are absolute worst case scenarios that we need to save that child's life, and we've got to be able to weed out the other cases that we can find a reasonable solution without burning the county's coffers, essentially, because it will get very costly if we continue the same mentality that we've had for a number of years.
And say a 14-year-old runs away from this county, filing a PINs and getting a warrant for that 14-year-old, maybe in Ohio or Nebraska, is a very useful tool in locating that child and getting the child back. So there will be PINs filings, and then when they come back, whether they're put in some sort of out-of-home placement or they remain with parent, And the other services, the reimbursement issue, we'll see how that plays out. But there still remains a valid reason for PINs. Child that has not committed criminal behavior, who may be involved in drugs or runaway or exploited. There's a placement for exploited youth now under PIN statute as well. So,
As it stands right now, beginning January 1st, the only option that law enforcement has available to them with a runaway or a perpetual runaway is return to home. That night at 2 o'clock in the morning, when they apprehend that runaway, they bring them right back to the location that they previously ran away from. That's all that the law allows them to do. Sounds crazy, but that's where we're at right now. We're working on it. Anything else? If anybody has any questions that arise, if there's anything, if you want to understand a little bit more about the background, I'm available at all times. You can contact the county attorney's office and I'll be happy to take any questions.
Thank you. That's it. Thank you very much.
Thank you.
That answers everybody's questions. All good. Well, that's an appropriate motion. If we'd like anything else.
Move to adjourn.
Second. Okay, we're adjourned. Thank you.